All right, well, welcome everyone. Thanks for coming to this course today. So this course is what everyone in construction should know about contracts. Now the purpose of this is I've been doing real estate law and working with contractors, subcontractors for about 12 years. And one thing that I see really consistently is contract problems. We see a lot of work done on kind of handshake deals, and then you get disputes over what really was that deal. What did you really owe me? What was really included in it? Other issues with breaches of contract. We see contract issues all the time, and so I think that there are some fundamental things that really everybody in the construction industry should know and understand about a contract, entering into contracts, and some of the things that go along with that. And so we'll go over that, some of the fundamentals that everybody should know. And at the end, I'm going to go into some contract provisions that you'll see in just about any contract. And there are contract provisions that use legalese that can kind of be a little bit wonky and a little bit hard to understand why that's in there. And I want you to be able to understand those and recognize them when you see them in the contracts, understand what they mean and why it's in there, and maybe more importantly, understand what you should do about it, how you can negotiate those terms, how it impacts you, and if you don't see them in the contract, you can have an idea of whether you want that in the contract that you're entering. So let's get started. Start with a pop quiz. Does a contract have to be in writing in order to be enforceable? So, say you show up on a job, you're a subcontractor who's agreed to install some drywall, and you talk to the homeowner. You say, yeah, I'll do this for whatever, $100. You're a cheap subcontractor, right? And shake hands, walk away. Do you have a contract? Well, let's look at the elements of a contract before I answer that question. So this is by law, and it's what we call common law. Most states, including Utah, we don't necessarily have a statute that lays this out, but it's developed in the courts over time that this is what you need in order to have a contract. First, there has to be a meeting of the minds, and that's the number one up there on the slide. It's kind of legalese, meeting of the minds, meaning sometimes it's called mutual assent, meaning everybody kind of is on the same page. And we'll get into a little bit more detail of what these are, but basically meeting of the minds means you're on the same page, you understand you're entering a contract. Second thing is there has to be offer and acceptance. Offer has to be made, that offer has to be accepted. And the third thing is there has to be what we call consideration, and we'll talk about what that means. So, the answer here then is no, you do not need a written contract in order to have these three elements. You can have a contract without it being in writing. And a verbal contract is actually every bit as enforceable as a written contract. The difference, though, is if you have to have these three elements in order to have a contract, how do you prove that you had all three of those elements? And even more relevant, what we see all the time is how do you prove some of the details? When was the work supposed to start? How is payment supposed to be made, etc. So yes, you can have a contract without it being in writing, absolutely, and it's absolutely enforceable. But how do you prove what was in that contract? And that's where we get into really sticky situations. When you don't have it in writing, we very frequently see disputes over what the details of that contract was, who breached, who was supposed to do what. So first kind of tidbit I have for you is I certainly recommend using written contracts, and I know it's pretty standard for a lot of aspects of the industry not to use written contracts. I mean, I get it. The attorneys do it too. You get a new job available to you. You want to jump on it. You don't want to have kind of that maybe awkwardness of saying, will you sign this first? You don't want anything to stand in the way of that going forward. But my experience is, and attorneys tend to see the worst side of it because we see it when it turns into a dispute. But my experience has been that when you don't have that written contract, all too often you end up regretting it, and what you pay, what you lose in the end, outweighs what you might have gained by having that few minutes of awkwardness with asking them to sign your contract. Also, my experience has been that if you have a good contract and it's well written, contracts can kind of be used almost like a marketing tool. They can set a tone. And I think that if you're dealing with somebody who's professional and responsible on the other side, they'll appreciate that. They'll say, there's some things that I want in writing too, And if it's written in a way where it doesn't look like you're trying to, screw someone over and take too much, then that can be clear in the tone of the contract, and I think it can actually do a lot to start the relationship off right. So there's other kind of practical reasons in my mind for using those written contracts. Okay, so let's go into those three elements. So first thing I said that you have to have under the law is a meeting of the minds, or what we sometimes call mutual assent. So there's no such thing as tricking somebody into a contract. You can try to do it, but it's not going to be enforceable, because if they didn't understand that they were entering a contract, then the contract's not enforceable. So that's what the law means when it says you have to have mutual assent. Both sides have to understand we were entering a contract. We had a basic understanding that this person was going to do X, this person was going to do Y. Now that doesn't mean that you can get out of an element of a contract by saying, hey, I didn't realize that was in there. That's not necessarily the case. If it was in writing, then you're deemed to have read it. You're responsible for knowing what's in there. So you can't say, well, hey, there's no meeting of the minds because even though that was in writing, I didn't read it. That doesn't work. But what mutual assent means is that you both understood you were entering a contract. It's no surprise to anybody that there was actually an agreement for things to be done and compensation as a result. Next element is offer and acceptance. So let me give you an example for how offer and acceptance might work. This is actually one, when I was in law school, I remember spending like 2 or 3 weeks on offer and acceptance in our contract course. And you think, well, that's crazy. It seems like it should be a simple element, right? There's actually a ton of case law out there. There's been a bunch of cases brought over time about whether there was offer, whether the offer was accepted. Some of these are things like, you see a billboard that says we're offering this great deal, 50% off, whatever, and you walk in and you expect that deal, and they don't give you exactly what you want. There's actually court cases on those sorts of things. Was that an actual offer? Was there actual acceptance? Did that create a contract? Something that you might see, and let me give you, these examples, of course, might be a little bit incomplete, but this will give you an idea of what we're talking about. Say you walk into a shop and you want to buy an air compressor, and the sales rep says, hey, I'll give you a great deal for that air compressor, $500. And you stand back and nod your head and say, yeah, that's a good price. You shake hands, you walk away. The sales rep thinks he agreed to buy that air compressor. We had a contract. You think, I told him that was a good price. I shook his hand and I walked away. Is there a contract? Is there offer and acceptance? Well, in that case, no, probably not. Offer and acceptance is similar and kind of plays into meeting of the minds. There's some similarities there, but basically there has to be a clear offer that this is specifically what I'm offering to you for this deal. This isn't like some general thing that I'm giving out to the world, some sort of like general discount. If it's just sort of generally spoken to the world and not specifically for that person in light of what they're going to give you in return, then that's not necessarily considered a hard offer that creates a contract. So specifically for that person, and then there has to be a clear, yes, I'm accepting your offer, I'm going to do something about it. So a lot of times in a contract, what you'll see then is some time spent at the beginning, these sort of whereas clauses, or sometimes just sort of some opening paragraphs, where you spend some time establishing that there has been offer and acceptance. And so, attorneys are sort of notorious for being a little bit long-winded sometimes in contracts, or at least that's how it's viewed. You might say, hey, this is a simple deal. Why are you giving me a 5-page, 10, 20-page contract for kind of a simple agreement? And the reason for that sometimes is because, well, there's some elements that we have to hit on. And we want to make sure that if this ever gets litigated, if there's a dispute, there's no way that they can prove that there wasn't actually a contract. And so offer and acceptance you'll deal with at the beginning of the contract. And there'll be some language that basically says, so-and-so wants to enter this deal to do X, so-and-so wants to accept that, and maybe it won't use the word accept, but so-and-so, also wants to enter this agreement to do Y, and so you're establishing that offer and acceptance language in there. The next one, the third element, is there has to be adequate consideration. So consideration is, again, something else attorneys are notorious for is we use words in a way that doesn't really make sense. Consideration in the law, and when we're talking about contracts, doesn't mean like caring for somebody like it might mean in common language. Consideration means something of value. And so we're usually talking about money. Usually a contract involves money, so money is consideration. But the other side has to give consideration too, so work, services that you're offering can be consideration. A product can be consideration. It's just that something of value. Each side has to be giving and getting something of value for it to be an enforceable contract. So there's a number of situations where a contract might not be enforceable because there's lack of consideration. So for instance, if you offer to do something for free, and there are court cases like this where somebody offered to do something because they were being generous and said, hey, I'll go fix that for you or whatever, and then you don't do it, you do half the job and you stop or whatever, that person could sue and say, we had a contract, you said you're going to do something for me. The other person says, no, you weren't paying me, there was no consideration, therefore it's not enforceable, and that person would be right. Typically that's right. If there was no payment, if it was a gratuitous offer, it fails as far as enforcing a contract, it fails for lack of consideration. Similar to that is if the consideration is so low that it's practically nothing. Now that doesn't mean that you feel like, hey, I was doing this for you, a little bit below market value. You can't get out of a contract by saying you lowballed me. I mean, if you accepted that and then you try to get out of it later and say, that their price really wasn't that good. I can get a lot more from someone else, or the market shows that this was really a low price that they were paying me. That's not what we're talking about here. That's not lack of consideration. And especially in Utah, I should say, the Utah courts tend to be really friendly toward contracts, meaning that they tend to want to enforce the contract. Now, there are other states that you could be in. Our firm is in Oregon. Oregon's a totally different atmosphere than Utah. Their courts are a lot different. Some other states, like Oregon and others, might be more inclined, the courts might be more inclined to look out sort of for the person who they feel like got a raw deal and say, well, this is really unfair and we're not going to enforce something that feels unfair and unjust. Utah, our courts and even our statutes tend to be more inclined towards saying, you're responsible for knowing what's in the contract and doing your due diligence beforehand. And so if you enter a contract where you're not getting a great price, you're probably not going to get out of that in the courts just because you can prove that it wasn't a great price. So again, that's not what we're talking about. But we're talking about a situation where somebody tries to bring up a defense to say, go back to that same situation. You offer to fix something in someone's home and then they try to hold you to it when you don't finish the job. If they raise a defense and say, well, I gave them a couple of sodas while they were in the house or something, something silly like that, or even something a little more substantial, but it's not really seriously value for what you were doing, then that's going to fail for lack of consideration as well. And then the third thing that we sometimes see is, and this one's probably more common than those others, is you have a weird clause in your contract that says something like, that basically lets one side choose what the consideration is going to be. So, for instance, if you have some kind of agreement, maybe it's a handshake deal, maybe it was in writing with a lumber yard that they say, if you pay us $1,000 now and you come here next Tuesday, we'll give you all the lumber that's available. You might think, hey, that sounds like a great deal. I'm going to get a bunch of lumber. You show up in your truck and you get 3 or 4 2x4s. Which I don't know, maybe $1,000 for 3 or 4 2x4s is where we're headed. But you only get a little bit of lumber, and that was because that consideration clause was really unclear. They could sort of decide what they were going to give you, or is based on kind of a non-concrete type provision. So that is usually unenforceable as well. Usually, if you were to take that to court and the lumber yard said, no, we had a contract, you'd have a pretty good chance of getting that shut down because the consideration wasn't concrete enough to really be considered something of value. Okay, so that's consideration. Now, I want to go into provisions that you're going to see commonly in contracts. So we're going to leave kind of how do you set up the contract, and what are the things that you should kind of understand in setting up a contract. When do you have a contract that's actually enforceable, and when do you not? We're going to leave that now and go into common provisions that are in contracts and things that you should understand about them. A lot of these provisions are things that you'll see kind of after the first couple pages of the contract. So usually the first little bit of the contract is going to be kind of establishing the relationship. Here's who the parties are, and here's what each party kind of expects to get out of this, and here's why we're entering it. Again, you have those sort of whereas clauses, which let me say, I don't have this on here, but that establishing who the parties are is really an important piece, because when you're operating under your business and you don't say clearly that it's the business entering this contract, or you slip up, and I've seen this where you're saying, I'm the party to the contract, that can have real liability implications for you down the road. So first of all, you want to make sure that they know and that it's in writing that they're entering this contract with your business. And you might be in a situation where you have different entities. You have sister entities and you have subsidiaries and that sort of thing. Maybe you're in that situation. So that's an important piece to establish, because business entities really do work for protecting liability. Maybe you've heard the term the corporate veil. The corporate veil is this idea under the law that when you have a corporation or an LLC or really any entity, any structure that's set up properly and used properly, it protects you. It's like a shield for you personally against getting sued, or more importantly, getting a judgment against you personally when it was really the business that was operating. And so you want to make sure not to kind of ditch all of that protection by not being clear in your contract about who's entering this contract. Which of your entities is the other side contracting with, and making it clear as well that it's the business and not you personally that they're contracting with. Now, you don't have to use a lot of words to do that. I mean, we just list who the parties are and make sure we list the right party. And it goes into something that goes into that as well is at the end you make sure that when you're signing as a representative of that entity. And so the signature line needs to kind of look a certain way to make sure that happens. After we get through all of that, though, we set up who the parties are. We kind of describe a little bit why we're entering the contract. Again, set up this idea of offer and acceptance. And you're going to then get into some of these provisions, and I've sort of put them in order that you'll usually see them in your contracts. Although we don't, of course, there's not one boilerplate contract you're going to use, but this is basically the order you'll typically see things. One of the first things that you'll see then after that is scope of work. This one's hugely important. What exactly were you agreeing to do or agreeing that the other side would do? Where does that work start? Where does it end? What all does it involve? My wife and I had a little bit of flooding. It's been about 3 years now. We had it was my fault. I shouldn't admit that on camera, but we at the end discovered it was my fault that I installed a new faucet in our kitchen, and I didn't totally connect one of the cold water connection. And it was just a small drip, but over time it dripped enough that it followed the line and went into our room next to the kitchen, and the water ended up getting under the flooring in there, and had a bunch of water damage. We noticed that our flooring was starting to bubble up a little bit, and the floorboards got some water damage. Drywall got some water damage. So anyway, that's what I get. I'm an amateur at plumbing, I guess. So of course we call in some subcontractors to come in there and fix it for us, and took up the flooring and fixed the flooring, and they had to tear into some of the drywall and do some drywall repair and do some stuff behind the drywall. Patched it all up when they were done, and left. Now we were getting it paid out by our insurance. We didn't have a general contractor. I mean, it's a small job. They were dealing with the adjuster. we thought that somewhere along the line there had been an agreement that we were going to get it painted when it was done. So they patched the drywall, they caulk it and everything, and then we discover, wait, nobody arranged for painters to be covered for with kind of the final price that we had talked about. That's a very sort of typical scope of work issue, right? You think you're agreeing to one thing, you get to the end of the job, you say, hey, what about the painting? Or what about hanging the drywall, or whatever it might be? Did our agreement cover that? Well, those are problems that we see frequently. So you want to have a really good scope of work provision. There's a few ways to do this. A lot of times in the contracts I do, I'll say, I'll have a scope of work, we'll describe kind of generally what the job is, and then you can have an addendum at the end. So if you really want to go into a lot of detail, if there's things that the parties have talked about, and if there's some kind of hot topic issues with scope of work, fill out that addendum. That's one thing. It's pretty common to say, generally, we're going to kind of understand that everybody here is reasonably intelligent, right? Hopefully you're contracted with people who are reasonably intelligent. So it's fairly common to use some sort of broad language, relying that everybody kind of understands what that means. We're gonna hang drywall. We don't need to tell you about how many nails we're gonna put in or whatever. You can say that and it'll be acceptable that, okay, we understand what that means. We're gonna build you a clubhouse. Of course, there's gonna be details about specs and stuff, but we can use that kind of broad language. So that's fine. That's fine. But sometimes what you want to pay attention to is what about the things that you're not going to do? And that's what you really want to make sure you put in your contracts under the scope of work section on an addendum or whatnot. If there's specific things that you're like, okay, we're not going to include that, and they need to know that, then put that in there. If there's things that are important to you that you're not held to, put that in writing. Put that in your scope of work. So that's one part of it. Next thing that we see under scope of work, the next way that we deal with that is using plans and specifications, and that's kind of usually the term that you'll see. So if you're on a project, and of course, this is going to vary, but if you're on a project where you have plans, you have drawn out plans, referencing the plans and specs is a great way to cover scope of work. Because then we can reference them, we can say we're attaching them as an addendum. Now, I'll warn you though, don't just use the term, because there might have been different versions of the plans. There might be a question about what is included in plans and specifications. Best practice is to say, we have plans and specifications, we're gonna attach them as an exhibit. And then it's clear to everybody which plans, which set of plans, which version we're talking about. You say we're attaching them as an exhibit, we're incorporating them into this contract. Use that word incorporation. Now that's a great shortcut, because then you don't have to worry about describing the project in great detail. It's described right there in the plans. Like I said, there's some landmines to navigate with that, though. I'll give you an example. 2 or 3 years ago, I was involved in a case where home builder was using the standard Utah Rep C for new construction, and it's a good form. It's made by attorneys, and there's good things in it. But keep in mind, if you're using the standard forms, they're written to be balanced. They're not written for you as the contractor specifically to protect you, or for the homeowner specifically. It's written to be kind of even-handed, to sort of strike a balance. So there's things you need to be careful of. And this particular one, he had used that standard Rep C for a home build, and we got to the plans and specifications portion of it. What happened was the homeowner had looked at the plans, and that standard Rep C does reference plans and specs, and it says that they're incorporated into this document. And as I recall, the language doesn't specifically say, it doesn't give a lot of detail or doesn't allow you to give a lot of detail for, is there an amendment to those plans, or attach them as an exhibit or anything like that. You could do it in an addendum, but it's not written into the document kind of as is. And so they just sort of relied on the fact that it said plans and specifications are part of this contract. Well, at least in one set of plans that was sent to the homeowner, it showed a finished basement. And the homeowner that's what he understood. He said, oh, I'm getting a finished basement. And that's kind of how we move forward with the contract, and in all the negotiations, the whole time he's thinking, I'm getting a finished basement. I saw it in the plans that were in the email. That's what I understand the contract is. The builder thought something different. And what happened, even kind of more specifically, is, as often happens, builder brought the homeowner to his design center, and they had a meeting at the design center and picked out finishes and picked out some other things. And the builder's understanding from that meeting was, we didn't talk about finishes in the basement. There's no finished basement. And they had kind of a process, and you've probably seen something similar where he picked some things on some software, clicked that the homeowner clicked that he accepted, and then it kind of attached, some kind of indication that he'd accepted that, and they were saying, well, that's basically a signature. And there is some Utah law that says, you don't have to have a wet sign name to be a signature. Other things could be considered a signature. So the builder thought, we don't have a finished basement. Despite what that one page that you saw emailed to you said, we've talked about other things. We had a design center meeting where we talked about other things, and so there's no finished basement. So the problem there was we had this real dispute over which one rules. What takes precedence? Does it take precedence that at the design center meeting there were some things that a reasonable person might have thought means there's no finished basement? Or does it take precedence that there was a page of the plans that clearly showed a finished basement? The contract didn't tell us which one prevailed, and that's the problem. So if you're going to reference your plans and specifications, you want to account for a few things. You want to account, first of all, for the fact that plans and specifications change. They could be amended. And how do they get amended? Is it an amendment if the homeowner scribbles on them and initials next to them and sends it back to you? Should we consider that an amendment to the plans and specifications? Is it an amendment if the builder does something similar? You need to cover that in your contract. And then the other thing is what I just described, or maybe something analogous to that. Maybe you're not doing a job where you actually have like a design center type process, but maybe you have some kind of meeting where you go over the plans, you go over finishes, you go over other details. And if you're having a meeting like that, if you're having multiple meetings like that, and try to anticipate what might happen in that meeting, how that might affect the plans, and at what point are we going to consider the plans modified and updated in a way that's binding and pursuant to the contract. Now this hits on some other contract provisions that we'll talk about, but it's really relevant to scope of work, and it's an issue that we see pretty frequently. If you're going to incorporate other documents, be really specific about what those other documents are and how those get amended and how those become part of the contract, or at what point modifications are or are not part of the contract. How is that binding? Next one's attorney fees. This is one that I like. Attorneys want to get paid too. So attorney fees provision is really important, and one that all too often I see not in contracts. If you're using a good professional, national, actually even national contracts. So Arizona, for instance, where I started practicing years ago, Arizona's law on attorney's fees says that it doesn't have to be in the contract. Doesn't have to be any mention of attorney's fees in the contract. If there is a contract, then each side can be reimbursed by the other if there's a breach of contract, reimbursed for their attorney's fees. Utah law is different. So when you're using national forms, be careful. Make sure that the form you're using has sufficient language for attorney's fees. So let me describe what that's going to look like. So in Utah and in most places in the country, we have what's called the American Rule. The American Rule says if you bring a lawsuit against somebody, you're paying for your own attorney's fees. And the other side's paying for their own attorney's fees too, win or lose. Everybody pays for their own attorney's fees. That's sort of the starting place for the American Rule. There's only a couple of exceptions to that. Well, a few, but really two important exceptions to that. First exception is if there's a statute, a state law, that specifically says that in this particular type of case, you can get your attorney's fees reimbursed if you win, then of course that state law is enforceable. we have a couple of those in Utah, but for the most part, the contracts you're dealing with aren't going to be impacted by those types of statutes. The other one that is relevant is that the other exception is that if you have a contract that says specifically, we call this the attorney fees provision, that specifically says, hey, if the other side breaches this contract and you have to sue them for it, they got to pay your attorney's fees. Then that's enforceable. Utah law specifically allows for that. They say attorney's fees provisions in contracts are enforceable. And in fact, what Utah law says is that even if that provision says only one side gets their fees, then that's automatically applies both ways. So even if your contract says, if I as the builder, or if you as the homeowner breach a contract and I have to sue you, then I as the builder get my attorney's fees. Well, then it automatically goes both ways. If the homeowner has to sue you, they get their attorney's fees too if they win. But keep in mind though, it's only if it's in the contract. So it's not automatic. This kind of goes back to this handshake deal issue. Yes, a verbal contract is enforceable, but how often when you have a verbal contract and you shake someone's hands, are you going to work out details like, oh, by the way, if one of us breaches, the other pays attorney's fee. Those things usually just don't happen in a verbal contract, which is why we really encourage putting it in writing. So make sure that if you want it, and I think you should want it, that your contracts have that attorney's fees provision that says, I get reimbursed if you breach. Next one is what we call an integration clause. This can come under a lot of different names. Integration clause is one of the common names for it, but basically what the integration clause says is this contract is what rules. We call it working within the four corners of the contract. What that means is that you might have had a lot of conversations outside of the contract. There might have been a lot of emails going back and forth. There might have been letters of intent going back and forth saying, here's what we think is going to happen. Here's what the relationship's going to look like. Here's what the consideration is. Here's what you're going to do. Here's where you're going to get paid, etc. But the integration clause basically says forget all that. When we have a contract and we've written down the provisions, this contract is the only thing that matters. And none of that other stuff's going to be enforceable anymore. Now you might think, well, that sounds like that's a raw deal, because what if we said something before the contract that I liked and I want to be able to hold them to that? I suppose that's a risk, but it's a much bigger risk to not have that clause in my mind, because what happens is you might have something that was said in an email or verbally or whatever prior to the contract, but I guarantee you they will too. And so you don't want to get in that dispute of, well, this or that was said and have to start looking at those other things. So you want an integration clause in there so everybody can agree and kind of settle, rest easy that what is in the contract is all I have to worry about. It's there in writing. That's what I'm going to be held to. I don't have to worry about what might have been said before or even after. And this usually isn't in the integration clause. Sometimes it is, where you'll also talk about if we're going to modify this contract, we have to do it in writing. We have to sign the modification, etc. Courts follow this as well. So if you go to court over an issue, and you say, but we did say X or Y while we were negotiating, the court's going to look, and if there's an integration clause in that contract, the court's going to say, I'm not going to look at that sort of outside evidence. We call it parole evidence. I'm not going to look at that parole evidence because you guys agreed that this contract, the four corners of the contract, is what rules. There's some exceptions to that. If a provision is ambiguous, meaning it's not clear, like we had this provision in the contract, but it wasn't really clear what we meant by that, then sometimes the courts will look outside to try to interpret that, to understand what it meant, and if you had conversations leading up to it that might help inform what that provision was supposed to mean, then that allows the court to kind of look past the integration clause. Sometimes if the contract's not complete, if there's something in there that kind of should have been dealt with, that might sort of lead along those same lines to some ambiguity that will allow you to look beyond just kind of the language that's already written in the contract. For the most part, though, the integration clause takes all of that outside noise out. And then the next one, and this one is It's not complicated. I think it's important. It's the choice of forum, and you'll often see this. A choice of forum clause says that if there is a lawsuit, then here's where it's going to be litigated. So this could be important, especially if you're dealing with like an out-of-state party on the other side, and you don't want to have to worry about a lawsuit being filed and you having to travel to Boston or whatever to defend yourself. You can agree in the contract that if there's a lawsuit, it's going to happen, it's going to be filed in and litigated here in Utah. You can even get more specific and say, you know, Salt Lake County, 3rd District Court, you know, whatever. There are some rules already under the law and under rules of civil procedure that dictate where a case can be brought. You know, you can't have somebody, you're working on somebody's home in Provo, and they're Provo residents, and you're a Utah company, and you know they have a vacation home in New York or whatever. They can't sue you in New York just because they have a vacation home in there. So there's already some laws in place that kind of dictate where a case can and cannot be tried. But there's also moving parts, and there's also situations where you can end up being sued in a forum that you don't want to have to travel to. And so you can take care of that by having a choice of forum clause. You can also go outside of those rules by having a choice of forum clause. So if you agreed with the other party that, hey, you know, we want to, if there is a lawsuit, we're gonna have it in Hawaii, you know, so we have an excuse to go to Hawaii or whatever, you can do that. Even though the case might not have anything to do with them, you can have a choice of forum clause that selects some other forum that for some reason that you guys want to agree to. And I won't get into the weeds on that. That's not always going to be totally enforceable, but if you do something like that, but it often will be. And then you can also choose the law that's going to apply. So for instance, again, you're a Utah company. Let's say you're doing work for somebody in, I don't know, in California. And you know that Utah law has some provisions, like that attorney's fees provision or something that you like, that's favorable. You can agree in your contract to say, we're going to apply Utah law. So it doesn't matter where you sue me. I'll come to California if you need me to come to California for a lawsuit, but that court is going to have to apply Utah law, and sometimes there's benefits for doing that. So when you see that in the contract, that's what it's doing. It's saying, and there can be kind of different parts to it. It's saying, it could be saying, one, where you have to go if there's a lawsuit, two, what law do we apply. You know, and of course that's going to apply to like arbitration and that sort of thing. I think, and then there's further assurances. So further assurances, sometimes called other action. So let me give you an example of this. Basically what further assurances is if you're entering a contract and more stuff is going to have to be done, you know, after the contract, like you're going to rely on the other side to have to sign some papers for you or something. So common situation we see is if there's financing involved. If you're entering some kind of deal where one side or the other has to go to the bank and get a loan, there's a good chance the bank is going to need something from the other party. So not from you. So if you're the person getting the loan, the bank might need something from the other party. They need them to sign something. They need them to send them some documentation. They need them to send them something. So in those situations, we have this further assurances clause that basically says if I need you to do something more, if something more is required in order for this contract to be fulfilled, you're agreeing to do it. That might come into play if you have the other side is really dragging their feet on something, if they start to get cold feet and for some reason they're not wanting to take some step that is going to be necessary for you, and it stops them from being able to say, hey, that's not me, you worry about that. You know, that's your side of the contract, you worry about that. The further assurances clause says, no, if I need you to do something, you're bound to do it. The contract says that you're gonna take whatever additional steps are necessary in order for this contract to be able to, you know, be fulfilled and go forward. So in sum, and I want to sort of hit on hit on the things that I think are most important. And here's what I recommend for your contracts then. First of all, again, I know I've said it, I'm going to say it again because I see so many issues with this, is use written contracts. And if you have a good contract that is sort of your boilerplate, it doesn't have to be real long. You know, if you're a subcontractor that's kind of going to a lot of homes and doing a lot of small jobs, it's not too hard to come up with a short contract that's not real intimidating for the other party to look at and sign. Use that written contract though. I can't tell you how many times, and the biggest issue that I see, probably more often than any, is that the other side doesn't pay. You know, you had an agreement to do something, other side doesn't pay, and you say, okay, you know, we need you to go after them and get them to pay. Well, step one is, okay, do you have it in writing? No, I don't. All right, so we can go to court, or you can testify that, you know, here was the agreement. First problem you're going to run into is they might testify something kind of different. It's not too often, but it happens that you're going to get somebody who'll just totally lie and say there was no contract. I mean, that's not the concern. I think we can pretty well establish there was some kind of agreement, but then we're going to very quickly get into, well, what did they really owe? Did you do everything you're supposed to do to earn that money? What was the timing of the payment? You know, maybe they have 6 months to pay you. So if you don't have it in writing, we're going to run into all sorts of problems with that. The second thing that you're going to run into, and we see this one all the time, is the no attorney's fees provision then. Okay, they didn't pay me. All right, we can take them to court. We can get them to pay. But, you know, you just spent, you know, in a good case scenario, maybe you spent $5,000 to get a judgment against them. Well, you know, now you might have spent more than the contract was actually worth. So then you really run into a problem with the attorney's fees issue. So get it in writing. That's my first. And then again, if we're summing up, I would say the other important thing that should really be high on your list is make sure the scope of work is well defined. And similar to that, and along the same lines, is make sure that it's also well defined. How do we modify the contract and any documents? What documents are we integrating into the contract? How do we modify the contract itself? How do we modify those integrated documents? For the most part, and of course there's going to be lots of details and lots of different situations, for the most part, I think that if you keep those few things in mind, then you're going to be in a lot better position than if you just kind of go in and are relying on handshake deals and everything. So I hope that's helpful. I think we're going to have these slides available to everybody. I'm happy to, since I'm doing this virtually and, you know, we don't have questions that can kind of be asked and answered, I'm definitely happy to respond to some emails, pick up the phone if you want to call me and say, hey, what about this situation, and bounce something off of me. You can say you said this and I didn't understand what you meant. That's fine. Happy to take those calls and answer those emails. So thanks for listening. I hope it was helpful.